Hi friends, non-compete and non-solicitation clauses are found in almost every employment agreement in India. So in this video, I will explain the position of law with respect to enforceability of non-compete and non-solicitation clauses or agreements in employment related matters. Before we start, I would like to request to subscribe to my channel if you have not, so that you can get regular updates on my upcoming videos. So friends, let's start with understanding the meaning of non-compete. Non-compete agreement or clause is used as a restriction that prevents an employee who leaves a company from working for another company involved in the same business activity. So as per this clause, we cannot join a competitor, and also if I am an employee of a company which has a shoe manufacturing business, as per this clause, I cannot go and start my own business or shoe manufacturing company. That would be violation of this clause. And now moving to the next aspect of this video, that is non-solicitation. Non-solicitation refers to a clause or agreement that restricts an employee from trying to get other employees to leave the company to work for someone else. So suppose if I am working in a company and I have some friends or colleagues there, and I'm trying to convince them or motivate them to leave the current employer and join somebody else or another company, that will be violative of this clause. Even after them I leave the employment, usually clauses or contracts of non-solicitation will have a time period of 1 or 2 years. Suppose I have left a company and it's been 6 months, and I am calling my previous company colleagues and asking them if they are looking for a job. We have a job opening, or motivating them or trying to encourage them to leave the company and join employment somewhere else. That is prohibited under non-solicitation. So this was the meaning of these two aspects, or these two clauses we can say. Now we will have to understand what is the law in India which governs these two clauses. So section 27 of Indian Contract Act 1872 says that every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. So if we analyze the meaning of this section, it says that any agreement which is in restraint of lawful profession or trade shall be void to that extent. So it means, as per section 27 of Indian Contract Act, non-compete and non-solicitation in India are not enforceable. So as per this clause, these two restrictions are void. Suppose I'm an employee of a company and my agreement has these two clauses. Legally, I am not bound to follow those two clauses. Section 27 has also some exceptions which are given there, but I'll not be going into the detail of exception provided under section 27. However, there are certain judgments which are passed by the courts and which act as an exception to section 27 of Indian Contract Act 1872. I think we should go to our next topic, so which is exceptions to non-compete. Supreme Court in year 2006 held in Percept Demark's case that a restrictive covenant which restricts the other person from his future liberty to deal with the persons he chooses for his endorsements, promotions, advertising, or any other affiliations, and such type of restrictive or restrictions extending beyond the tenure of the contract is clearly hit by Section 27 of the Indian Contract Act and is void. In another case, the High Court of Delhi in year 2008 held in BLB Institute case that under Section 27 of the Indian Contract Act, a restrictive covenant extending beyond the term of contract is void and not enforceable. The doctrine of restraint of trade does not apply during the continuation of contract for employment, and it only applies when the contract of employment ends. So friends, it's very clear from these two judgments that the non-compete restriction is only valid till the duration of employment. Suppose I am working in a shoe manufacturing company. If I start a similar kind of a business during my employment with the company, then that will be violation of this clause, or that will be breach of this clause, and courts in India have enforced such clauses. But once my employment is over, if the clause has any time period, say 2 years or 1 year, then that part of the clause will be invalid. So we can say that non-compete clauses in India are enforceable with respect to employment related matters, but only during the period of employment with that particular employer. Now we'll go to the exceptions to non-solicit or non-solicitation. Friends, Delhi High Court in year 2006 held in Wipro Limited versus Beckman's case that non-solicitation clauses are valid in India. So this clause, as per this judgment, is valid during the period of employment and even after the termination of the employment. So if I leave employment with my current employer and I join somewhere else, I cannot try to solicit the previous colleagues or whoever are there, my friends in the previous organization. So non-solicitation is a restriction which is upheld by the law in both cases during the period of employment and post employment as well, but there has to be a reasonable time which should be given in the agreement for the restriction of non-solicitation after the termination of employment. So as we have analyzed the law in India, wherein we saw the Section 27 of Contracts Act, we have also seen the judgments which were passed by various courts. So I think it is better if we can compare non-compete and non-solicitation laws with respect to other jurisdictions as well. That will broaden our understanding with respect to this concept. In India, we have already discussed, and going to United States. In United States, the law is completely opposite. In United States, is completely enforceable. So, as per the law, non-compete and non-solicitation are fully enforceable. But there is one state in USA, that is state of California, where non-compete and non-solicitation are not enforceable at all. But if we look at United Kingdom, laws again are very similar to India when it comes to non-compete and non-solicitation. So comparing these three jurisdictions, we have two places, India and United Kingdom, where the law is same when it comes to non-compete and non-solicitation. And in United States, it's acceptable widely except the state of California. So in US, every state has its own law, and there are a lot of aspects of law which are mostly covered by the states itself. And even though there are federal laws as well which has, say, superiority over the state laws, but state laws also have their own place in United States of America. So friends, thanks for watching this video. Please subscribe to my channel if you have not subscribed, and also give your comments or any suggestions if you have, or any topic you want me to make a video or explain anything about that. You are welcome. Thanks a lot. Bye.